I have a secret. Alcohol DUIs, the government has two ways to win. They just prove you're over point away beyond a reasonable doubt. That's a guilty verdict. In the trial defense of drug DUIs, there's no magic number like a .08. So government may only have one way to win. I want to use this segment of our trial defense of DUI cases to talk about drug DUIs, specifically maybe marijuana DUIs, but kind of the whole gamut of drug DUIs. Now, you may remember that in previous videos, I talk a lot about the distinction between DUI 23152A and 23152B, the two types of main alcohol DUIs under the California Vehicle Code. And you may remember that I explained that 23152A requires the government to prove beyond a reasonable doubt that you're too drugged to be trusted to drive safely. And 23152B requires them to just prove that you're beyond a reasonable doubt somewhere above .08. It's very difficult at times for the DA to prove DUI with marijuana or DUI by under the influence of drugs or narcotics. More difficult, I would say, than DUI alcohol. They have to actually prove beyond a reasonable doubt that the narcotic in your system or combination thereof actually made you too impaired to be trusted to drive safely. The bottom line is drugs, and particularly marijuana, the science has shown that these substances tend to pass the human body at a different and less predictable rates than alcohol might do. With alcohol, for example, a lot of toxicologists are able to say, well, if somebody's BAC was at this point in the night, maybe about an hour ago they were at this point, and an hour before that at this point, etc. And it's often pretty easy for those experts with the established science or easier to give a more full timeline of your actual impairment with alcohol DUIs. With drug DUIs, it's very tricky how they move through the system. And the other thing you have to know is that when your blood is run through the lab is supposed to be detecting not just for what's called active ingredients of a narcotic, but also how much of it is a metabolite or stuff left over from the drug. In a situation where perhaps you smoke marijuana a day or so before driving, it's probably going to be still in your system if your blood is drawn. But is it still affecting your ability to drive? Well, if it's all metabolite at that point, probably not. The National Highway Traffic Safety Association presented a report to Congress on the issue of marijuana impaired driving in 2017. I encourage anyone to read it. It's very interesting, but the biggest takeaway that I took from it as a trial attorney was the Highway Traffic Safety Association pretty much conceded that there is no reliable psychomotor test that officers could use to detect whether somebody is too impaired by the effects of marijuana to be trusted to drive safely. Layperson's terms, field sobriety tests are of very, very limited, some people would argue almost no value when trying to evaluate whether somebody is actually under the influence of marijuana, such that they're too stoned to drive, for lack of a better phrase. So if you have a marijuana DUI case, or really any type of drug DUI, you and your lawyer should really pressure the DA to dive deep. Look at the video. How bad do you really look in the field sobriety tests? And again, if those even matter for reasons that I already discussed. Does the DA plan on actually using their own toxicologist to review the information? In some counties that I practice in, for drug DUIs, the DA's office more routinely produces a toxicologist's opinion even before the matter is set for trial, because they want to actually have a better sense between the parties about how strong or weak the case is. And that's only one opinion from their toxicologist. Maybe you have another toxicologist who wants to take a second look. How bad is the actual driving? Is the person actually swerving in such a way that indicates that they're too impaired? Or is it something more innocent, like bad registration, for example, is the reason why they get pulled over? And therefore, if there's no bad driving, how are they going to prove the person was too impaired or too stoned to drive? Furthermore, as you might remember some other videos, in cases where somebody has drugs only in their system, the DMV might not be interested in taking any action on their license from the start. Mind you, if the person is found guilty of drug DUI in the courts, under 23152 subsection F or G, for example, those convictions will trigger a suspension anyway. So be aware of that when you're deciding whether to take your drug DUI case to trial. If you or somebody you know is fighting a drug DUI case, please have them give us a call. Thanks and stay safe out there.